Hello, it's Phillip Taylor speaking from Richmond Green Chambers, and this morning I'm looking at a book from the Legal Action Group, LAG. It's an excellent book. It's just come out now in a second edition. It's called Giving Legal Advice, an Advisor's Handbook by Elaine Heslop. That's the front cover there. There's the side, you can see it's a second edition there, and that's the back of it. You can see what you've got. Again, you've got a little bit of shaded area there to give you an idea of where the appendices are. There's a lot of very useful information in this book, and the appendices in particular are very helpful. There's quite a large amount of stuff, things like the client care letter and various other things to help you with drafting, basically. The book itself has got a useful shortish index at the back, which you can see there, just to give you an example. Runs to 430 odd pages. The way it's actually structured is you've got paragraph numbering, which you can see on the sides of the publication. There are some footnotes as well, not that many, but there's a lot of very helpful, very practical information in it. Do read, as usual, the preface for all of these books. That's actually the front page as such. Elaine Heslop has written a useful pointer as to what the content of the book is about. You've got contents there, then you've got things like advice frameworks, and then the book runs through, and there's some useful little examples. You can see that, the sort of problems you might have. Now, giving legal advice obviously covers a very wide range of areas. It's not something that's very specific in that sense. Now, my wife and I have written a review which is in the journals and on the web, and we've given it the title Essential Reading for Lawyers and Non-Lawyers Alike, in other words advisors, the definitive guide to court processes and the courts. Now, can I just point out that this deals with everything prior to the creation, late April 2014, of the family court, and I'm recording this after the implementation of the act that creates the family court, but we are generally talking here about a much wider area of advice giving for legal matters. This is what our review says. The Legal Action Group, LAG, the Access to Justice charity, has just published another indispensable reference book which litigants and their advisors, not to mention lawyers, will love, especially those with clients who can't quite meet the costs involved in going to law. And of course, one of the problems, as we all know, is the funding of any proceedings, which are extremely expensive. Now, the book itself gives you some idea as to where you stand, and the giving of legal advice itself is really the very first step, because it's on the basis of the giving of the legal advice that one then thinks about whether we should take proceedings or not. So what we've got here is a book which is a plain speaking title, giving plain speaking work of reference information now in the new timely second edition. Its publication is particularly helpful at this particular juncture in 2014 in view of the widespread decrease in legal aid availability and the corresponding increase in the number of people who are litigants in person in court, which is of course clogging up the system quite substantially. Litigants, obviously in person, are litigants appearing unrepresented in court, and they don't necessarily know much about what to do or how to do it. Obviously there are requirements by opposing lawyers and the courts and the judge to try and sort things out, but the whole system is pretty unhelpful, frankly, to parties unless they've got proper legal representation. And even then, there can be serious problems with the way in which the processes of the court or a particular point of law can be dealt with. That's why the professionals are in. But none of us know everything about this, so you have to take as much help and advice as you can. Quite often the judiciary will ask for some help if they have difficulties with precedents or a particular way in which a case should actually be disposed of. Let me just quote what Elaine Heslop says about the book. She says, "This second edition aims to provide support and guidance to those who continue to engage in the vital function of advice provision in order to give as many individuals as possible access to justice." That is the phrase which has been around now for a couple of years, access to justice. basically it's a right, although we're not calling it that, but it's the right to go and get some justice where you've actually suffered an injustice. The content, therefore, of the new edition has been considerably revised and updated, and illustrative examples have been given whenever the law is referred to, especially in the areas of things like social welfare, which I think this is partly aimed at, including small claims in the civil courts, which many people appear as themselves as litigants in person in those types of proceedings. A quick trawl through the very useful table of contents will indicate that just about every conceivable issue or matter faced by litigants has been covered and explained in a succinct yet detailed manner, from the court structure itself to advice skills to further advice specific to the litigant in person. And that really is the beauty of this particular book. It should be emphasised, of course, that the book is a particularly handy one for those who've never been to court before, and it's useful for them to obviously read it beforehand. Helpful documents and flow charts throughout aid navigation, and besides the listing of advice agencies, there's a useful index which I showed you earlier, and 4 appendices which include precedents, courses and training, and of course draft letters. There's a list of useful organisations included, and an exceptionally enlightening tract dated April 2013 from the Bar Council entitled A Guide to Representing Yourself in Court. Now, I've seen it and it's very useful. It doesn't tell you everything, but it gives you some idea when you're impecunious and have a real problem funding or having to deal with being sued. As for the courts themselves, there's plenty of advice for the unwary on dress and behaviour, plus numerous tips on the various practicalities involved. Quote, "Be ready with the case number. Be prepared to put even the simplest request in writing. Be firm but polite with court clerks," and so forth. All common sense, but very much the sort of thing you've got to think about. And it's amazing how in the stress of the occasion one can miss that out. Also note that courts and tribunals are not particularly child-friendly. You have been warned, and that's happened on many occasions. There may be changes in the future, but at the moment they don't like children in courts, and it can be a real problem. They always consider that childcare arrangements should be made beforehand. That's all very well, but it's not as simple as that, and there are no creche facilities generally, so you've got to be very careful because you can't take children into courtrooms themselves. Even trying to get permission can be quite difficult, so do bear that in mind. Let me conclude by saying that, suffice to say that reading this book will result in litigants and their advisors being better prepared, better informed, and more confident in navigating legal processes and the legal system. As a thorough and readable guide to best practice for both advisors and clients, we think that this book should be in every practitioner's library, because it's very useful to start people off with, so they've got some idea of what they're facing. The publication date is stated on the book as at February 2014. I'll just remind you what it looks like. There it is again. There's some useful comments about what the book actually offers. And as I say, just looking at it, case management, for instance, is dealt with there in some detail. One of the points I would make with you is that when you're looking at documentation, there's some comments on that. One of the problems is that people will come to court for the first time and think it's all going to be over that day. It's not like that. There'll be adjournments and problems. We're trying to sort some of this out with some reviews of civil justice administration procedures and so on. But at the moment, the likelihood of getting a resolution on the first appearance, the first appointment of a matter is pretty unusual. Thank you very much to Elaine Heslop and to LAG. It's a great new publication, now in the 2nd edition, and very helpful for all, and we're very grateful to all of them for the work they've done on it. Thanks a lot. Bye-bye.